Good afternoon, friends. This is the 32nd meeting of the study circle. I invite Ms. Madhusmita Bora to give a welcome address.
A very good evening to everyone. I, on behalf of the study circle today, find it a pleasure, big pleasure to welcome Sir, Mr. Gurukrishnakumar, Senior Advocate, Supreme Court, to enlighten us on the topic of the day, which is a 9th schedule of the Constitution of India and Judicial Review. Now, though the list of achievements of Sir is endless, but it is like, we have somehow tried to give a very concise introduction about him and his achievements. So Sir graduated in law with a university rank, and while in college, he was an active debater and participated in and won many prestigious moot court competitions at the national and international level. He represented India in the Philip C. Jessup International Law Moot Court Competition in the year 1991 and finished in the top 8 teams of the world. As a British Sevening scholar, he has studied English and EC Commercial and Corporate Law. He worked as a legal resource for one of India's leading corporate houses, which is L&T, before taking up private practice. He practiced on the original side of the Madras High Court for a few years before coming to Delhi to practice in the Supreme Court of India. He worked in the chambers of Mr. C.S. Vaidyanathan, Senior Advocate, and Mr. K.K. Venugopal, Senior Advocate, who is the present Attorney General. He was designated as a Senior Advocate by the Supreme Court of India in November 2012. Sir has argued cases involving various branches of law, like constitutional, commercial, and corporate laws, apart from a host of civil and criminal matters. He has also appeared in many high-profile political matters. Some of the notable cases include cases dealing with the scope of judicial review, in exclusion of groups for affirmative action, anti-defection law, election law, etc. He argued successfully on the application of the principle of legal seat in arbitration law, even before its recognition by a constitution bench in the Balco case. Even recently, he appeared successfully for e-commerce majors regarding online sale of products of direct sellers. He also appeared in a matter relating to functioning of foreign law firms in India. Now, this is just a very concise gist of his achievements. His achievements are endless, so it is not possible for us to finish it off in 2-3 minutes. But today, he's going to enlighten us on the subject of the day, and we are all looking forward to this. Thank you so much.
Thank you, Madhusmita. You have kept the promise of being very kind about what I have done in the past, and I hopefully will be able to keep up the promise that you have kept up by giving some interesting material to our friends who have joined us today evening. Now, friends, the topic chosen for today is the 9th schedule and judicial review. 9th schedule, if I may put it in one word, is a very dark and massive jungle. Because one look at the schedule would show that there are as many as 284 entries. That's really the beginning point. Now, how did this 9th schedule come into being? And what is its history? I was talking about the number of entries there being as high as 284. Now, a glance at the entries would also show that they relate to various types of law or various branches of law. You have some land reform laws, you have some laws dealing with agrarian reform, you have laws dealing with industrial recognition and regulation and development of industries. You have an entry dealing with reservation, being the Tamil Nadu law. You have some entries dealing with certain other branches of law, like election laws, etc. Now, what is the beginning of all of this? The beginning for all of this is the very first amendment to the Constitution of India. The first amendment to the Constitution of India took place in 1951. Now, this amendment was brought in to save and to protect certain laws dealing with essentially land reforms, land tenures, and agrarian reform. This is, I think, the first important point to be noted, because this history has a very, very important bearing on what ultimately is found to be the position with regard to validity of the ninth schedule itself in the recent decision of the Supreme Court in dealing with its validity after the decision in Coelho's case. Coelho's case, in fact, is the benchmark or watershed, as it were, dealing with the validity of this law in terms of judicial review of the law was added to it. Now, as I said, the ninth schedule was brought in through the First Amendment. Before the First Amendment, what was the position? We have with us Article 13 of the Constitution. If you have one look at it, it will show you a couple of interesting things. I'm not sure if the host can just show Article 13 for a minute, just for a second, so that I don't have to really start reading it and waste people's time on that. Yes. Now, please see, the caption says laws inconsistent with or in derogation of fundamental rights. Now, this says all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Then, subclause 2, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So, therefore, two things. Clause 1 talks about laws which are already in force and says that if they are void or inconsistent with the provisions of this part, meaning part 3 of the Constitution, then they are taken to be void to the extent of such inconsistency. The second part is a bar on the state from making a law which takes away or abridges the rights conferred by part 3 again, and declares that any law made in contravention of this clause shall, to the extent of contravention, be void. Then subclause 3 talks about what the meaning of law is for the purpose of this article. Now, please note subclause 4. Nothing in this article shall apply to any amendment of this constitution made under Article 368. Now, this was an insertion subsequently by an amendment, by Constitution Amendment Act. Now, I'm not really now going into the question of whether a constitutional amendment will become part of Article 13 or will become part of law for the purpose of Article 13, because that's a separate area which I don't really need to bother myself, because we are dealing with a concept of judicial review in the backdrop and on the premise of basic structure of the Constitution, about which I'll be talking now. Now, the reason why I refer to Article 13 is this. You will see that validity of any legislation made by any legislature, be it a state legislature or the parliament, is considered and adjudicated upon by the judiciary by reason of Article 13. Now, Article 13, read with the provisions in the Constitution dealing with power to legislate, that is to say, competence of legislation with reference to Articles 2, 46, etc. Now, this becomes the basis for laws to be tested as to whether they are constitutionally valid or not. Now, having mentioned this, I want you to now refer to Article 31B of the Constitution. Now, please go to 31B. Yes. Now you will see 31B with the heading Validation of certain acts and regulations. Now, very important, I'll read that a little slowly. Without prejudice to the generality of the provisions contained in Article 31A, none of the acts and regulations specified in the 9th schedule. Now you find the reference bodily in the Constitution to the 9th schedule. None of the acts and regulations specified in the 9th schedule, nor any of the provisions thereof, shall be deemed to be void, or ever to have become void, on the ground that such acts, regulations, or provisions is inconsistent with, or takes away, or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree, or order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force. Now you see the stark difference between Article 13 on one hand and 31B. This is one of the reasons why I wanted to first refer to Article 13. I hope I'm making myself clear on this. Now, if you see this, it can, according to me, be divided into three component parts, at least for the time being. The first part is how none of the acts and regulations specified in the 9th schedule, that is those which are enlisted in the 9th schedule, nor any of the provisions thereof, that is individual provisions of the statute, either the act as a whole or any of its provisions, shall be deemed to be void or ever to have become void on the ground that such act, regulation or provision is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this part. So this is the first component of 31B. The acts set out and enlisted in the 9th schedule shall be deemed not to be void or have become void. On what ground? On the ground that they are inconsistent with or take away or abridge any of the rights conferred by any provisions of this part, that is part 3. This is the first component, as I said. Now please see the second component according to me. And notwithstanding any judgment, decree or order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force. The second component, according to me, is the non-obstructive provision, where it says, notwithstanding any judgment, decree or order of any court or tribunal to the contrary, each of the said acts and regulations shall continue in force. Therefore, there may be a decision of a court which has declared void a particular legislation. Now, the moment it is added to the 9th schedule, it shall continue to be in force. This is the second important component. Now, the third component. There is a small area reserved, which is the subject provision, which says, subject to the power of any competent legislature to repeal or amend it. Now, this shows that even though a law is added to the 9th schedule, the legislature which made it, it could be a state legislature or it could be the parliament. It has the power to repeal it or to amend it. This is the third component. Now, the first important point to be noted, therefore, is this means that any law which may be inconsistent with any provision of Part 3, as for example, saying that you can't move court for challenging it, or it may be offensive of Article 14, it may be offensive of Article 19, it may be offensive of Article 21, Article 15, any one of the rights set out in Part 3. This article says, no, if it is included in the 9th schedule, it will be valid and it will not become void. Second, the further reinforcement is, even if such a law has been held to be so by any judgment, if it is added in that 9th schedule, then it will be valid. Now, obviously, this is a provision which is overarching, extreme, and sweeping. In the language of some decisions or many decisions of the Constitution Bench dealing with Article 31B and 9th schedule, it is some kind of a protective umbrella. That's the point to be noted. It is a protective umbrella. The second expression to be borne in mind when we deal with it is how it is a constitutional device which has been brought in to protect certain laws. Now, these are the fundamentals that I wanted to place before you before I go into the First Amendment. As I was telling you at the beginning, it was through the First Amendment that this Article 31B and the 9th schedule were brought into the constitution. Now, when it was brought into the constitution, the then Prime Minister Pandit Nehru said, this act is needed because we need to have laws to protect tenants. We need to have laws to protect agriculturists. We need to have laws to ensure that the zamindari system which is being followed or which was being followed at the time does not result in any kind of exploitation. He even went to the extent of declaring that he is neither a zamindar nor a tenant, but he has always been intricately connected with the life of such people, and how therefore he wanted to bring in such a provision to ensure that courts of law do not declare invalid laws which are made for protecting certain depressed sections. He said any law made by parliament or any state legislature which is towards agrarian reform, which is towards land reforms, should not be interfered with by courts of law. That, he said, was the purpose of the law. In fact, the amendment was referred to a select committee. One of the members of the select committee even went to the extent of saying that the provision as contemplated was something extraordinary. That was the extreme nature of the opposition which was given to this law, or to this proposed amendment, if I may say so. Nevertheless, it became part of the constitution. Now, there is another background to this. There were certain land reform laws which are made in some states like Bihar and a few other states. And there were contradictory views taken by high courts as to the validity of these laws. Some high courts said that this was invalid. There are a few other high courts which said no, these acts were valid. Now, you will have to remember also that this kind of contradictory approaches was also in the light of the existence of Article 19(1)(f) in the Constitution of India. Article 19(1)(f), which provided for right to property as a fundamental right. Therefore, given all these reasons and given this background, this insertion by way of First Amendment was made to the Constitution. But the point to be noted is the insertion was on the basis that it was to relate to agrarian reforms, land tenures, land reforms, and would be done only to safeguard laws which are made to protect such issues. But as time passed by, more and more laws got added. That is how we today see as many as 284 entries to it. Now, this is one part of it. What about the validity of Article 31B and the 9th schedule attached to it? One of the first cases was Shankari Prasad's case. In Shankari Prasad's case, the validity of this article was upheld. This was followed by Sajjan Singh's case in the mid-60s, where again the validity was upheld following Shankari Prasad's case. Then we have Golaknath's case, which purported to set aside these two decisions. Now, I am not going into the nitty-gritty of the reasoning, the arguments and the approaches or the rationale in these decisions, because you will be entering into a huge area of discussion on intricate constitutional issues which may not be immediately necessary for consideration for the topic that we are now looking at in terms of judicial review of the 9th schedule, because they are perhaps relevant in the sense of historical and academic perspective. So I thought for the completeness of record, I would refer to these 3-4 decisions. So please, therefore, you can make a note of Shankari Prasad Singh's case, Golaknath case, Sajjan Singh's case, and ultimately you come to the watershed decision in constitutional law being the Keshavananda Bharati case. Now, Keshavananda Bharati case overturned Golaknath's case. Because I have mentioned about Golaknath's case here, I thought I should first highlight that aspect. But what is relevant for our immediate discussion is the propounding of the basic structure theory in the said decision. All of us are familiar with it. All of us talk about basic structure and basic features of the Constitution and how the power of the Parliament to make a law cannot be in such a manner as to alter the basic structure of the Constitution. And the moment somebody puts forth this proposition, we are reminded of the decision in Keshwananda Bharati's case. Now, Keshwananda Bharati's case was rendered on 24th of April 1973. There is something relevant about this date because this date becomes some kind of a benchmark, as it were, to determine the validity and also the power of judicial review of acts which were added to the 9th schedule before or after this date. To put it in historical terms, this date becomes like the date of BC and AD for the purposes of inclusion to the 9th schedule. Now, having said that, I want to now move on to the next most important point which is relevant for this discussion. The basic structure theory was propounded in the Keshwananda Bharati case, which meant that Parliament cannot make any laws which tamper with or compromise the basic structure theory. Now, what about the right to include a law which has been held to be invalid in the 9th schedule and thereby make it immune from judicial review? Is the first obvious question that will arise in the light of the law laid down in Keshwananda Bharati's case. Obviously, it cannot be said that there can be no judicial review. This is where the discussion about judicial review of the 9th schedule comes into focus. This is how we place in perspective the discussion of the judicial review in the context of the 9th schedule. Now, there are 2 or 3 other decisions which I want to now mention to you and then discuss the features of those decisions. Following Keshwananda Bharati case, we had the Indira Gandhi case in 1975. Now there was an amendment made to the Constitution by an insertion of an article being Article 329 capital A. Now that provided that the election of high functionaries like the President or the Prime Minister will be subject to separate scheme of adjudication, and the validity of the election of such office bearers and functionaries cannot be subject to scrutiny in courts like any other elections. The validity of this law was challenged in the said decision. Now, the importance of this law and the validity of the challenge is because this was sought to be added to the 9th schedule. The Supreme Court said it is obviously offensive of the basic structure of the Constitution and therefore said it is invalid. Therefore, please make a note of Indira Nehru Gandhi's case. Now, there are 2 other decisions which are important. Further amendments to the Constitution, because there are so many additions to the 9th schedule that we may perhaps lose the essence of the main issue by getting caught up and bundled up in the nitty-gritty of those individual facts, and therefore I'm consciously making an attempt not to be entering into the nitty-gritty of those amendments, etc., because we may really end up missing the woods for the trees. Now, 2 decisions which are to be noted in this regard are Minerva Mills case. Please make a note of it in 80, and Vaman Rao's case. Now, Vaman Rao's case is very important because that decision said any inclusion of any law in the 9th schedule after 24/4/1973 can be tested on the touchstone of basic structure. That's important. Now, this is the first part of what I wanted to have you to look at and consider, because this is the backdrop. Now comes the subsequent developments after that. As I was pointing out, there are various additions to the 9th schedule from time to time. Then there was this one particular addition being the Gudalur Janmam Estates Act from Tamil Nadu, which was held to be void in the Balmadi's case sometime in 1972. Now, that act was included in the 9th schedule. There was a challenge to the validity of that act, which resulted in a reference being made to 9 judges of the Supreme Court sometime in 1999. There, the reference said that the statement of the law in Vaman Rao's case and what the implication is and what the contours of judicial review are were to be decided by an authoritative pronouncement of the Supreme Court, and therefore the matter was placed before a 9 judges bench. And that is how the decision in Coelho's case came into being. Now, Coelho's case, the citation is 2007, 2 SCC page 1. You have the AR equivalent of that. I mean, that can always be located. Now, Coelho's case is extremely important because of 3 or 4 important aspects which, according to me, have been discussed, debated, and settled. Point 1. This is, I think, one of the most important points which have been discussed, debated, and adjudicated upon. The scope of amending power of the Constitution under Article 368. 1. 2. The status and position of the fundamental rights and whether they are or not a part of the basic structure of the Constitution. 3. What is the scope and extent of judicial review when a particular law is included in the 9th schedule? I think these are the 3 most important principles which, according to me, are to be construed, understood, and taken to be the highlights of Coelho's decision. In fact, while talking about point 2, namely the status and position of fundamental rights as being a part of the basic structure, there are 3 or 4 connected, very, very important principles and concepts about which I'll talk when I get into that particular issue. Now, coming to point 1, the power of amendment of the Constitution. Now, having taken Keshwan and the Bharati to be the paradigm, because that has now laid down that there is no unlimited power to amend the Constitution, the court in Coelho considered what the position is in the light of the right of the Parliament to use 31B as a constitutional device and as a protective umbrella. That's how the discussion of the amending power becomes relevant. Now, one of the first points to be noted is how the court noted the political theory and jurisprudential theory and recognized in some decisions, I think even in Minerva, how there is a distinction to be made between plenary power of making the Constitution itself and the constituent power of amendment of the Constitution. And the third category being the legislative power of making a law itself. These are extremely important. 1, plenary power is the power where the body brings into being the Constitution itself. Now, that is a power which is separate and which is a distinct plenary power, because that is the power by which the original document is brought into being. As distinguished from that, the power of amending that document is really a derivative power. Even though it's a constituent power, it's a derivative power and therefore subordinate. This is one of the principles which has been specifically discussed, debated, and pronounced upon with great detail in Coelho's case. The court says the inclusion of any law into the 9th schedule is essentially the exercise of amendatory power. That's the first point to be noted. Therefore, the court says the inclusion in the 9th schedule will not give absolute immunity to any law because the amendatory power is subject to the basic structure of the Constitution. The second important point regarding the issue of amendatory power. The court says that Article 31B, even though gives the power to give immunity to certain legislations, is not an absolute immunity. That's extremely important. Now, in the process of discussing all that, something very important needs to be looked at. Coelho's case says the validity of Article 31B is really not something that the court is going to go into. This is very, very important according to me. Court says, I am not going to be now looking at the validity. In fact, there was some argument raised saying that 31B was held to be valid in Keshwananda Bharati's case. The court, in fact, undertakes a very detailed discussion on the reasoning in Keshwananda and says, no, we may not be able to say with certainty that it has been upheld. But nevertheless says, we proceed on the assumption that 31B is valid. Of course, the court takes reference to Shankari Prasad's case and Sajjan Singh's case, which I referred to right at the beginning, where 31B was upheld. But the court says that the right to include is not something which will give absolute immunity to a law, because the basic structure stands as a guiding force to ensure that the amending power is not used to tamper with or tinker with or alter the basic structure of the Constitution. This is one important point to be noted. Now, while doing all this, another point that the court referred to, which according to me is very important to be borne in mind, is that the court says that the provisions of 31B and the 9th schedule itself were brought in for certain purposes, namely to give protection to certain laws dealing with agrarian reform and land reforms. Therefore, this is something which must be made available and should be available to the parliament. In fact, the court says there must be some kind of a balance between directive principles of state policy and fundamental rights under Part 3, and says it is really a balance which has to be achieved, and it is on a balance that we have to decide whether such laws can be made or included in the 9th schedule or not. Now, it's another point to be noted here is this, a third sub-point, if I may say so. The court compares Article 31B with Article 31A and 31C. That's important. Court says 31B does not have any guidelines or does not have any indication of what kind of laws can be added to the 9th schedule, and says this has to be compared with Article 31A, which talks about laws made for acquisition of estates, jagirs, inams, etc. And 31C, which is a provision made for giving effect to laws which are to give effect to certain directive principles of state policy, particularly Article 39. Therefore, the court says 31A and 31C have certain guidelines, and they are with reference to certain specific areas of legislation or areas of law which are made to further certain larger interests of public good, and therefore the law can always say that it cannot be challenged on the ground of violation of any of the fundamental rights contained in Part 3. Whereas 31B is something which does not have any such indication. You remember when I read out 31B, the bare text of 31B, you notice that it is sweeping. It is omnibus. Therefore, the court said it must be borne in mind that it is general, and therefore it has to be read in such a manner as to ensure that the basic structure is not violated. Now, this is the first point according to me, which is important. Now, the next point is, as I told you, the position of fundamental rights as being part of the basic structure of the Constitution. Now, all of us recall that Keshwananda Bharati case is also otherwise very generally and generically referred to as the fundamental rights case. Now, it's very curious that everybody ultimately talks about how the Keshwananda Bharati case decided that there is a basic structure to the Constitution of India, and how the Parliament cannot amend the Constitution in such a manner as to affect this basic structure. Now, what about fundamental rights? What was the decision of the court in Keshwananda Bharati case on fundamental rights? Now, you will recall that Keshwananda Bharati case was decided by a bench of 13 judges. And it has the opinion of all 13 judges. And there is a 7:6 majority decision. In fact, the annexure to the decision, which runs into several hundreds of pages, called the order of the court, is something which is very important because that contains the conclusions of the court. In fact, as an interesting aside, scholars have debated very extensively on what the reasoning of the individual judges are and whether at all there can be any kind of unanimity which can be attributed to the opinions, or whether at all there can be any particular conclusion which can be taken to be the majority opinion, because they say the order of the court which is attached to the opinion of all the judges may not perhaps reflect the reasoning of the individual judges accurately and correctly. That's an aside, because again, as I said, it's a separate area where perhaps if one were to enter into a lecture or a debate on the fundamental rights case, it may perhaps extend into at least 4 or 5 sessions on what the contours are, because there are so many nitty-gritties which are involved in that case. It brims with various political concepts, various constitutional concepts, various abstruse issues, because you will recall that one of the criticisms of the decision even today, after so many decades, is that the basic structure theory propounded in that case has resulted in an unwritten constitution being brought into being, where the court can look at the text and also look at the overall intention of the constitution to decide what the basic structure is, or whether a particular feature constitutes a basic feature of the constitution or not. Now, that apart, coming back to the position of fundamental rights. Now, Keshwananda Bharati case discusses fundamental rights. It says they are a part of the basic structure of the constitution. In fact, Justice Khanna clarifies his decision in subsequent Indira Gandhi's case. Then you have Justice Chandrachud's decision in Minerva Mills and in subsequent cases, where he talks about what exactly he had held in Keshwananda Bharati case. Now, being a very, very, very elaborate decision, and that too opinion of all the judges, it's bound to be diffuse. Now, this is where the discussion in Coelho becomes very important on the status of fundamental rights as being part of the basic structure. The first point to be noted in this regard is the Coelho dispensation says, in line with the earlier decisions, including Keshwananda Bharati, that fundamental rights are amenable to amendment. They can be abridged or curtailed. But the important rider which is added is the abridgment or curtailment cannot be in such a manner as to affect the basic structure of the constitution. In fact, it may be worthwhile to look at what the conclusions in Coelho are, because even as I'm pointing out the 3 important points, one is the scope of the amending power, the position of the fundamental rights, and the extent of judicial review. Now, what are the conclusions? Because again, this is a decision which is running into a very elaborate discussion on various aspects. Now, if you come to the conclusions, just make a note of it. Paragraph 151 of that decision. That gives the conclusions. It says, I'm just reading it for your sake. I'm not too sure if somebody is having the SEC volume so that it can be seen on the screen. Otherwise, I'll just read it from the book itself. I'm not sure if the host has that. Perhaps it's not there. So I'll just read it just for your immediate reference. Conclusion, paragraph 1 says, a law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine, or it may not. If former is the consequence of the law, I'm pausing, that is, if it abrogates or abridges the rights guaranteed under Part 3, whether by amendment of any article of Part 3 or by an insertion in the 9th schedule, such law will have to be invalidated in exercise of judicial review power of the court. The validity or invalidity would be tested on the principles laid down in the judgment. Please note this, when a fundamental right is abridged or abrogated, it will be tested on the touchstone of basic structure. The last part, what I read to you, the validity or invalidity, whether that curtailment of the fundamental right, whether it affects the basic structure or not, will be tested on the principles laid down in the judgment. This is important. As somebody says, the devil is in the details. What are these principles laid down in the judgment? The court says there are certain overarching principles which guide the functioning of the Constitution. Take, for example, equality under Article 14. Court says equality per se in 14 is not something which can straight away be taken to be a part of basic structure. If 14 reflecting equality is offended by offending an overarching principle like an egalitarian equality, meaning to say it is compared with other fundamental rights and other directive principles of state policy and binding constitutional values, only then it will be held to be violation of the basic structure. This, according to me, is one of the problems which is attached to this decision, where the court says that fundamental rights may be amenable, but if they are going to result, may be amenable to amendment, but if the amendment will result in violation of the basic structure, then and then alone will the law be held to be invalid. This, according to me, is something which has resulted in tremendous confusion. In fact, there are at least 4 or 5 decisions where COILO has been sought to be applied to determine validity of certain laws. I'll just refer to that once I complete the main points which have been decided in COILO. Now, I therefore refer to you conclusion 1. The problem connected to that I just outlined to you. Now, please see conclusion 2. The majority decision in Keshavan and Bharati, read with Indira Gandhi's case, requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys the basic structure. The impact test would determine the validity of the challenge. So the second point the court says is, how do you decide whether there is a violation of the Constitution? It says you look at the impact. Then conclusion 3. All amendments made to the Constitution made on or after 24/4/1973, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of the basic or essential features of the Constitution. Please mark this. On the touchstone of the basic or essential features of the Constitution as reflected in Article 21, read with Article 14, 19 and the principles underlying them. To put it differently, even though an act is put in the 9th schedule by constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure if the fundamental rights or rights taken away or abrogated pertain to the basic structure. Again, they come back to the basic point of how fundamental rights, even if they are amended, they have to affect the basic structure if they are to be held to be invalid. Now, while saying that again, the court refers to basic or essential features and takes reference to 14, 19 and 21. So the question will come whether only these fundamental rights are basic or essential to the Constitution. This is where the problem in the decision arises. Is there not therefore a hierarchy of fundamental rights which have been created? This is one of the things which has now been debated very extensively as a fallout of this decision. Is there or is there not a hierarchy of fundamental rights which have come into being? In fact, you may make a note of some paragraphs. I think it's paragraph 48, paragraph 56. Paragraph 56 of COILO talks about fundamentalness of fundamental rights. 48 talks about how Article 21 is the heart of the Constitution. In fact, there is a separate chapter running to about 10 or 15 paragraphs on Article 32. Please recall, Article 32 is part of Part 3. All of us recall the study we had in college, where it was said that 32 is the soul of the Constitution according to Dr. Ambedkar. Because this is one of those unique features in our Constitution where the right to move the court itself is a fundamental right. The right to move the Supreme Court itself. Now, therefore, several questions are thrown up by the discussion and the conclusions. Basic or essential features as reflected in Article 21, 14 or 19. In fact, in another part of the judgment, they are referred to as a golden triangle. 14, 19 and 21. Please also recall the other very, very interesting facet of constitutional law. As I said, this decision, according to me, is one particular theme which has at least 5 or 6 other distinct and dominant constitutional themes which are separate by themselves. One I told you was Keshavananda Bharati itself, which propounded the basic structure theory. That itself is abound and replete with various ponderables and constitutional issues. Then there is also this very, very important principle of reading the fundamental rights together. We go back to A.K. Gopalan's case and downwards various decisions culminating in Maneka Gandhi's case, where the court said, we are not going to look at fundamental rights as independent silos. They are all to be read together. The moment there is a challenge to any action, whether it be state action by way of executive action or legislation or any other law, you have to see what the impact is on fundamental rights strung together. Please also recall even the most recent decision recognizing the right to privacy in Puttaswamy's case. Now, very important, because over the years, you will recall the court has read into Article 21 various rights. It is not found in the written text of the article itself. In fact, one opinion of one of the judges in the Puttaswamy case is very important. Justice Chalameshwar compares the rights which are to be read into Article 21 as some kind of black matter, whereas in space, you have various things getting in. Now, the reason why I'm saying it is, therefore, 14, 19 and 21 have to be read together, and Coelho's case takes note of that law. There is a discussion in the judgment on that also, and says how it forms a golden triangle. Now, these are all some of the aspects which are referred to and says that only therefore if some essential feature of the Constitution is violated, can it be said that a law which is added to the 9th schedule is violative of the basic structure of the Constitution. Then I come to conclusion 4. Justification for conferring protection, not blanket protection on the laws included in the 9th schedule by constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute sought to be constitutionally protected, and on the touchstone of the basic structure doctrine as reflected in Article 21 read with 14 and 19. This is again another part where they reiterated. Now go further, please see further. By application of the rights test and the essence of the rights test, taking the synoptic view of the articles in part 3 as held in Indira Gandhi's case. Now this latter part is again another major issue of discussion, where it says, looking at 21 read with 14 and 19, by application of the rights test and the essence of the rights test, taking a synoptic view, please see the kind of diffuse language which is used. Now, what is this rights test and essence of rights test? Now, this rights test and essence of rights test are found in paragraphs 140 and 142 of Coelho's case. Please make a note of it. I think it will not be fair on my part to be troubling you anymore with the nitty-gritty of this, because it is so diffuse. It would be well worth for somebody to have a look at it. Where the court says, the standard to be applied to decide whether a particular law when it violates any fundamental right, how do you decide whether it's valid or not? Whether that violation is violation of the basic structure or not. Court says you take the rights test or the essence of the rights test, as the case may be. In fact, this became necessary because the court took note of the formulation of the law in another decision. All of us recall the decision in M. Nagaraja's case in 2006 that had come in just before the decision in Coelho's case. The court there was dealing with provisions in Article 16. Reservations. Now, court says we have to look at equality not just as is found in 14, 15 or 16, but as something which is part of an overarching principle, as a constitutional value. This is where the court says, therefore, depending on the law which is included in the 9th schedule, you adopt the rights test or the essence of the rights test. This is the other conclusion reached. Now, the court also says that if there is a law which has been upheld by the court prior to 24/473, then it will not be subject to any scrutiny. However, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the 9th schedule after 24/473, such a violation or infraction shall be open to challenge on the ground it destroys or damages the basic structure as indicated in Article 21, read with Article 14, 19, and the principles underlying therein. Therefore, these conclusions will show us how, as I was pointing out, the three important features have to be understood. Number one, the scope of the amending power. Number two, the position of the fundamental rights as being or not being a part of the basic structure. There are two important fallouts, as I was saying. There seems to be some kind of a hierarchy of the fundamental rights itself, and when you look at any challenge to a law for having been included in the 9th schedule, saying it violates any provisions of Part 3, you are looking at whether it can be taken to be a part of the basic features or basic structure of the Constitution or not merely because it is found in Part 3. This is the second point. Third point is the extent of judicial review. The court says judicial review will take place on the principles, as I had indicated broadly, on the rights test and the essence of rights test. In fact, there are various other discussions. There are some very, very important paragraphs on dealing with the various portions of the fundamental rights in the light of Keshavananda Bharati case, Indira Gandhi case, Minerva Mills, and Vaman Rao, and various other decisions. But again, it will be so diffuse in terms of understanding the broad structure, because I wanted to really give a bird's eye view of the whole thing, because it is so very intricate and, as I said, a little nebulous in various places. I thought this would be the best way of encapsulating the basic framework. Now, this is so far as this decision is concerned. In fact, one important point, the court repeatedly says how fundamental rights are extremely important. They are basic to the Constitution, and how this protective umbrella cannot give absolute immunity to the law. This is something which I had pointed out earlier. The court says, in fact, if we don't look at it that way, then fundamental rights themselves will become like some kind of a parchment in a glass enclosure, which has only historical value. They refer to Minerva Mills case. You remember all those famous museums where you have all these great works of literature and great works of historical importance being exhibited in enclosed glass cases. They say Part 3 also will become that, and therefore they say it cannot be so. Now, having given you therefore a broad overview of Coelho's case, now let us see how this has been applied. As they say, the proof of the pudding lies in its eating. Now, one of the important cases that I wanted to highlight here was Glanrock's case. Now, Glanrock's case is reported in 2010, 10 SEC 123, 10 SEC page 96. Now, that decision dealt with the application of the decision in Coelho's case to the individual law. You remember I mentioned about the Gudalur Janmam Estates case, whose validity was challenged and therefore the matter was referred to 9 judges bench. Now the matter comes before a 3 judges bench to test the validity of the individual law. Now the court holds that that particular law is not invalid on various grounds. But what is important for our purpose is, the court says that we have to look at equality not in vacuum or not merely reflected in Article 14, but as egalitarian equality. Now, some of the concepts which are so nebulous and diffuse, you will just appreciate when I refer you to some portions in Glenrock's case. Now, just take, for example, paragraph 24. Court says, coming to the applicability of the judgment of the 9-judge bench in Coelho's case, time has come for us to explain certain concepts in the judgment like egalitarian equality, overarching principles, and reading of Article 21 with 14. In this connection, one needs to keep in mind what is called as the degree test. Please note this. I told you about the rights test and the essence of rights test. Now, in applying Coelho's case, which laid down these tests, paragraph 24 in Glenrock refers to degree test. Now, I read further. Ultimately, in applying the above 3 concepts enumerated herein, one has to go by the degree of abrogation as well as the degree of elevation of an ordinary principle of equality to the level of overarching principles. You see how at once this is so very diffuse. Now, this and various other such approaches are replete in this decision where they ultimately say the law is valid. I don't want to burden this discussion today with the nitty-gritty of these. There are various paragraphs. I can circulate all of that once the discussion is over, so that you can read and appreciate the drift of what I am endeavoring to place before you. Now, this is one of the issues. Now, therefore, this Glenrock estate is one case where the Coelho principles were sought to be applied to decide whether a particular law, even though included in the 9th schedule, is valid or not. Then you have, this is in fact a case of application of the third important point in Coelho, which I had mentioned, namely the judicial review or the manner and extent of judicial review of laws which are included in the 9th schedule. So also the second point about how fundamental rights have to be understood and how whether a fundamental right can be taken to be part of the basic structure or not. Then you have Ashok Kumar Thakur's case, decided in 2008. It was a case again on reservation, Article 15, where they applied Coelho's case. You have at least 5 or 6 other cases where Coelho's case is sought to be applied. You will see in each of these decisions, there are certain peculiarities attached to all of them in terms of the approach adopted to decide whether a particular law which is added to the 9th schedule being valid or invalid because of violation of fundamental rights. Again, the list of those cases I will circulate because for paucity of time, it may be very difficult for us to enter into a debate or discussion on each one of these decisions because each one of them has its own set of facts and factual background, which by itself will take tremendous amount of time. Now, therefore, these are all some of the broad features in Coelho's case, which have a bearing upon the inclusion of any law in the 9th schedule and the judicial review of such inclusion and the validity of those laws. There is yet another important point to be borne in mind. Now, a law which is added to the 9th schedule, you will recall, as I had pointed out in the beginning, may be a law made by a state legislature also. In fact, Article 31B, you will recall the third component of Article 31B talks about how the power to amend or repeal the law continues with the legislature. Now, this means that it is essentially a law and it is not really a part of the Constitution. In fact, that is specifically mentioned in Coelho's case. A law which is included in the 9th schedule does not really become a part of the Constitution. Now, what is the implication of this? On one hand, you are looking at the inclusion of any law into the 9th schedule as a constitutional amendment and deciding whether that law offends the basic structure. And on the other hand, you are also clarifying that that particular law is really not part of the Constitution itself. Now, the question that therefore that will arise is, what about the principle that ordinary laws cannot be tested on the touchstone of basic structure of the Constitution? That is one of the aspects which some scholars and writers are highlighting as some kind of a ponderable arising out of this approach. There are a number of judgments which say that it is only constitutional amendments which will be tested on the touchstone of the basic structure of the Constitution. Ordinary laws are broadly tested only on other grounds such as lack of competence. That is, the legislature does not have the competence in terms of the 7th schedule to make a law on the subject, or violation of Part 3. Now, of course, you have another major area again of law. As I was saying, this really spawns various independent constitutional themes. You have the concept of manifest arbitrariness, which has now come in as a principle or a ground for striking down legislation. Recall the decision in McDowell's case and earlier decisions also, where the court said that there can only be 2 broad grounds to invalidate a law made by a legislature. I'm talking about an ordinary law. The 2 grounds being competence of the legislature which made the law, and 2, violation of Part 3 of the Constitution or any other constitutional provision. Now, there is this look at the principle of manifest arbitrariness as a ground. Now, there are number of decisions which have come in, starting from Shaira Banu's case and so many other cases which have come following that. Now, this is another area. The point I wanted to highlight for the purposes of our topic was how an ordinary law, even though being an ordinary law, is tested on the touchstone of basic structure of the Constitution, by it being included in the 9th schedule through a constitutional amendment. Therefore, these are some of the issues, according to me, which are extremely relevant. And I think, as in any other constitutional principle, this is a law in the making, and there are bound to be various other issues which crop up. And even now, there are various ponderables and there are issues of discussion. And these are aspects which contribute to the organic growth of the Constitution. Thank you so much.
Thank you, sir, for taking us through Schedule 9. We're waiting for questions to be asked in the chat box.
Yeah, sure.
And Mr. Jaykumar has raised his hands and unmute himself.
Yes, Mr. Jaykumar, how are you doing?
Mr. Guru, I'm friend of Ramanujam, UB Bangalore.
Oh, yes, I'm able to.
Identify me, good.
Yes, I'm able to place you immediately.
Excellent. You're 100 century you scored. Okay. See, my short point is this Schedule 9 is the brain wave of VKT Chari. Am I right?
Yes, absolutely.
Can you just elaborate on that? How did we get this idea? I mean, if you know.
But see, as I was saying, the history of this 9th schedule is something which is extremely intricate. I was talking to you about the discussion in the Select Committee when Nehru brought this in. Now, there were certain laws which had been made, as I said, Bihar, Maharashtra, and if I recall, I think it was the estate abolition law in Tamil Nadu, which was the subject of controversy. Yeah. That is how this was brought in as some kind of an overarching power made available to the legislature. I go back to the discussion in the Constituent Assembly.
Yes.
Nehru had said, no Supreme Court or no judiciary can act as the third chamber. In fact, he went to the extent of saying that no judiciary can stand in the way of the will of the parliament. That's how the discussion and the thought process started, and how the 9th schedule was brought in, where they said you have a certain set of laws where basically you are wanting to protect certain laws dealing with agrarian reforms, and therefore please place them in a certain pedestal where you give the protective umbrella by saying that they will not be questioned on the touchstone of a violation of Part 3. Now, you will also recall that all this took place because of Article 19(1)(f) being present in the statute book. 19(1)(f) as a fundamental right to property was available. It was only in 78 by the 44th Amendment that it was removed from Part 3 and added as 300 capital A as a constitutional right. Therefore, that history is something which is very, very elaborate. I can give some references by way of the books which refer to the discussions, and then again, it's a very huge topic by itself. I thought I'll give only a snapshot of it.
But you've done very well on this 31B analysis.
Yeah.
Class, really class. It's actually, it started with umbrella. There is an exception. There is the court order. And the Coelho's case is you're beautifully done. Hats off to you. And, yeah, you've become younger now.
Thank you. Thank you.
Sir, one other question.
Yes.
Does not the court in all the decision impose limitations on the constituent power of the parliament with respect to the principles underlying fundamental rights?
Absolutely, without doubt. Please recall what I was pointing out. One, the plenary power of making of the constitution is the ultimate or the absolute power. Any changes to it, even though part of the constituent power, is a derivative power. That power is not something which can be used to undermine or to change the basic document which has been made on the basis of plenary power. I hope I'm making myself clear on this.
Yes, sir.
Therefore, when you say constituent power, please don't mistake it as a power which is a power unto itself. Underlying this, please recall, this is where the underlying premise of the Constitution has to be understood. The underlying premise is this: the Constitution recognizes separation of powers, but not in the strict sense. It is a written Constitution. It is a controlled power which is given to the Parliament, and importantly, the judiciary is given as part of the power of judicial review to determine whether the other organs of the state are functioning within their powers given under the Constitution. Which is where you will have to understand that this really does not amount to taking away constituent power in that sense. I hope I've made myself clear on this.
One,
Yeah.
Dr. Babu has thanked you and appreciated you for the richness of your knowledge, which is reflected in your speech. So
Oh, thank you. Thank you.
I think that's all the question.
Yes.
I request Mr. Om Prakash, Senior Counsel, to give vote of thanks, sir.
Very good evening, Mr. Gurukrishnakumar. It has been a wonderful and erudite session. I believe that the members who have participated today have been enriched to a large extent as to understand principles. You had wonderfully started your session, delivery of your talk, by referring to the number of entries which are found in 9th schedule and took us to the relevant provision by which the 9th schedule has been brought in and the protection which is given to the entries which are found in the 9th schedule. Thereafter, you have traveled on the various constitutional judgments. You have not, if I have to say that you have not left even one, though you would not have said the facts and the law which is laid down. You touched from Sankari Prasad till date to the latest judgment on the privacy case, Dr. Puttaswamy's case, and brought us to the every gamut of how these challenges happen and how the courts look at it. And finally, the touchstone of it is that you brought out a point that the laws which are included in 9th schedule, being an ordinary laws, but for being included in 9th schedule, it remains as one another statute, one another law book of some state or the center. By bringing into the 9th schedule, a constitutional validity is given, rather a constitutional amendment is made. Therefore, it becomes part of, that was the wonderful point of it, to bring out the essentials of the 9th schedule. Thank you very much for having spent a lot of time on this. And I personally know that how busy you have been running between courts and Supreme Court, even otherwise your times in conference, I had known how difficult for people to even have a word with you. So in that context, the participants of today's study circle session have been benefited to hear you for about 1 year, a continuous flow of thought, questions of law, facts, decisions, referring to even judges' names as to who had pointed out which portion of the judgment. Thank you very much for your wonderful time. Thanks for all the members who have joined this evening. Thank you once again to all of you.
Thank you very much. For my part, I thoroughly enjoyed participating in this because it is really a participative and appreciative set of people who will enthuse you to speak what you believe are essential features. And I'm really thankful to the very knowledgeable set of people who have participated today. And I look forward to participating with you in the future also. Thank you.
We will always come back to you for further things.
Thank you.
Thank you.
Thank you, sir. Thank you.